Yeah, I think the only reason he was asking that is for authentication purposes. So there's an evidence rule that requires that before evidence gets admitted that it's authenticated as being real and what it purports to be. I feel that that's the reason he asked that specific question. And he already has in his pocket, the prosecutor, the ability to be able to argue the hearsay and that this information is not relevant. So guys, let's start with the most basic thing, right? But when this is a great case for law students, before any evidence gets admitted, it has to be relevant, right? What is relevancy? Relevance has the tendency to prove or disprove a fact that's at issue or a legal point that's at issue. Now, right over to my right here, about 2 feet, but I can't grab it, is my evidence rule book. And in my evidence rule book, it's the groundwork that you can either admit evidence or not. So if your audience knows that you're not just allowed to willy-nilly throw anything out there, it's got to meet these prerequisites. Authentication is one of them, and the other one is an exception to the hearsay if the judge in fact finds that it is hearsay. So that's the process that's going on right here. And if the court allows it, then it gets introduced. Now, guys, we talked about before, as a prosecutor, tactically, I would never, especially if it was a close call. If it was a close call, it's never, I'm not even making the argument, okay? But if it's not a close call, maybe I'll make the argument. But look at the judge's perspective. This judge, I can assure you, and Judge Ashley, you were a judge for a long time, wants nothing to do with coming back here and retrying this case because they made an error with regard to not allowing the defense to introduce evidence. And if she rules in favor of the defense, the state can try to appeal it. Whether they would, I don't know, interlocutory, but after the trial, the state can't appeal it. You know who can appeal it afterwards? The defense. So will that weigh in on a close call on a judge's practical perspective? I can throw it back to you, Judge. Does this really go on? I think it does in the case that I've seen where the judge says, you know what? I'm not risking a reversal for a ruling on this. The jury can determine to what extent they're going to believe this information or not.
Two kinds of judges. Some say I'm going to rule so I don't get appealed, and some say I don't care if you appeal me or not. I'm going to rule the way I want to. But the thing I need to say is I felt like her tone was, defense, you better prove to me why that meets these two prongs to be admissible.
Yeah, she's put them through the grinder throughout. You can't argue with that. Quickly, Bob, I only have about 30 seconds here. Was this the right way for the defense to start their case?
I think it is. I think that this is obviously something the government does not want in there. I mean, we're really guessing here, but there seems to be something that's going to pop that you know is not going to be complimentary at a minimum to the investigators or the investigation in this case. So I think they want to get it out sooner. Primacy and recency, right, Michael? They want to get it to the jury as fast as possible while they're opening their case.